The Appellate Division 3rd Department, based in Albany, is unique among the 4 Appellate Division departments for the simple reason of geography. Since it's based in Albany, the capital, it hears the bulk of the cases involving state government and its agencies. It also admits the largest and most diverse class of attorneys each year. Welcome to Meet Your PJ, a production of the New York State Judicial Institute. This series is designed to introduce you to the 4 presiding justices of the appellate divisions, the courts that have the last word and are really the courts of last resort for most cases in New York, since the Court of Appeals handles only a small percentage of those cases. I'm John Carr, Senior Advisor for Strategic and Technical Communications. Today we're honored to have as our guest the Honorable Elizabeth A. Garry, Presiding Justice of the 3rd Department. Justice Geary grew up in a dairy farm in the hill towns of rural Albany County. She graduated with honors from Alfred University and Albany Law School. She practiced law for 12 years. She served as a law clerk and a member of the town of New Berlin Planning Board. She was elected and re-elected town justice and elected to the Supreme Court in 2006. 2 years later, just 2 years, she was promoted to the Appellate Division by Governor David Paterson. And on January 1st, 2018, she was named Presiding Justice by Governor Andrew M. Cuomo. Justice Geary is a commissioner and past co-chair of the Richard C. Fala LGBTQ Commission of the New York Courts. Judge, thank you so much for joining us today. Let's first discuss your background, if we could. What do you learn on a dairy farm that's applicable to life in general and perhaps the practice of law?
That's so wonderful. Thank you, John, for that intro and starting right there with my deepest and fondest roots. My father always said that I would be so grateful to have been raised on a family dairy. And as a teenager particularly, I found that a very doubtful proposition. My friends had this thing called free time, and I envied them terribly, but the lessons that I learned in that cyclic process of what all agriculture is, the returning to very hard work season after season, but also seeing the accomplishment, when you have prepared a field for planting, or you have done the hay, cut the hay and prepared the hay and stacked the hay in the barn. And, when you've done those tasks, you get a deep feeling of the value of hard work. And that has carried me. And my father, back to my father, he loved the farm, and he would say to me, "Oh, you'll be so grateful." And he's passed now so many years. And he was so right, John. I am so grateful for that background and all of the attachment that I still hold to the natural world. Springs from that, and it's predominant in my personal life. My enjoyment of our amazingly beautiful planet. And I know I'm going on too long, so thank you but you started with a topic that's so near and dear. So thank you, John.
So there must have come a time when you decided you'd rather be a judge than a farmer.
Did I mention the really, it's such hard physical work. And so quite literally, there was a time when I thought long and hard about, what is the future? And it's so physically demanding. Every single day. We owe a tremendous debt of gratitude to our nation's farmers and, people who work in agriculture of all sorts. And a lot of our population tends to be more urban or suburban, of course, but the work they do is just so challenging in every way. Most of us, we watch a weather report, with some interest. Oh, should I carry an umbrella when I go the few feet from the parking lot to the office? It's just such a different life experience. So, yeah.
Now, your department covers an enormous and very, very diverse part of the state. You've got, I think, 28 counties stretching from Kingston to Canada. You've got medium-sized cities, you've got the state capital, you have some of the most remote, most rural areas of the state. How is that reflected in the type of cases that you review?
the thing that I think every single judge and maybe every person who works at the third department might share, John, is that the thing that's so amazing about it is the scope and the diversity of what comes before us. You know, that the breadth of what we get to grapple with in a very deep way is just stunning. You know, the learning curve for a new judge on my court is, you know, no matter what background and life experience you bring to it, the learning curve is sharp and steep. It's really demanding because that geographic diversity brings such a different array of problems and disputes. And as you say, the urban, the suburban, the rural, and all the types of law that we grapple with. So the state cases, yeah, I know we'll get into more depth with some of that. So, but that is, everything is based on geography, John. Things really, everything at its heart is a local as it works its way up. And as you've said, you know, we're the mid-level court, deciding things that have been through a legal process. But what we see is just vast in its basis and background.
Now, while the range of cases that you take is certainly extremely diverse, your court has never been diverse in one particular way, through no fault of your own, of course, until just a few years ago when Justice Sharon Ahrens was appointed. There'd never been a judge of color. And Justice Ahrens came from outside the department. The problem, of course, is that in 27 of those 28 counties, they have never, ever elected a Supreme Court justice of color.
Yeah.
What are your thoughts on this?
My thoughts in the briefest form, John, it must change. And yesterday would have been soon enough. Really, that must change. And my other thoughts are, as you know, as we tape this, we are living in a period of tremendous change, which brings tremendous opportunity. We are, in my rather optimistic, perhaps, view, we are on the brink of moving in a much more profound way toward realizing the dream of our country. You know, the unrealized dream. It has never been achieved. And the real promise and God, you just, you know, the beating heart of our nation, John, and I know that's sweeping rhetoric, but it's so true. The heart of our nation is the promise of fair and just and equal treatment of people. And we might be in the place right now where that will be coming. It's right around the corner, isn't it? And we are not there yet. I mean, as you said, any look at the data will show that we have not reached a level of equality. Representation in our government is a critical value on that path. I have always expressed in regard to to making that happen, given the scenario of that you described in your opening remarks, that I've always been open to appointments from other departments for the moment, so that we can reach that as we currently have. But really, all sorts of groundwork has to be done within the political structures that exist. You know, getting to be a judge is a political achievement, and I call upon the political leaders to make changes in the ways that they evaluate candidates for these positions. One of the things, as you know, pending, the chief judge has an initiative to expand the courts that are opportunities for advancement to the Appellate Division. And that is one of the clear benefits of her plan, is that it will expand the potential pool of people serving in the mid-level appellate courts. So
that would instantly make a whole lot more people, a much more diverse group of people eligible for the Appellate Division.
Yes, qualified and having the important skills in every way, but coming from from a broader swath of our society, and also in every way. Yeah, background, diversity is across all sorts of measures. It's not simply race, it's not simply sexual orientation, it's not any single item. It is the more diverse the group, the more people are represented, and the more sound the decision making is process. Is.
Well, we certainly see that in your court. You have people from the major cities
Yes.
on your court. You have people like you who are from rural areas. You have people on your court really from many parts of the region who come from with much different life experiences.
Yes, and that's actually really, that is important. And frankly, when you look at if you were to look at the map, John, the 28 county region, it's important to me when we fill committee positions as well as the court, to have representation from the different areas, to not just have people serving from one particular region, because no matter what, people will have a what's in my backyard perspective. And so getting the legal system, although it's uniform, there are different ways of approaching things in my 6th district than the 3rd and the 4th, and so all of that, it matters.
The one commonality, though, is that, and by virtue of your location, as I said in my opening remarks, is you hear, I imagine, the bulk of the cases involve state government. You also admit last year 3,300 new attorneys.
Yeah.
Those factors make the 3rd department different from any of the other, from the other 3.
We, John, I don't know if what your question, but I'm going to jump in and say we take great pride in both. That one of the people I revere, and I did a little movie segment with him, the Honorable Leonard Weiss, and his great quote is that the 3rd department is the crown jewel of the New York State court system, and those two factors are both of those things you've so well identified are things we take great pride in. We do a tremendous admissions program nationally and internationally, with a very small staff. Let me mention that. We really we have good, hardworking folk who make that all happen, and I'm grateful to them. And then the state government cases are in many ways the most interesting things, in my personal view, that we get to grapple with. Yes.
How so?
They're the ones, every kind of case. As soon as I say that, I think, now did I just discount criminal or family law or, environmental cases? They all have their own drama, their own pull, their own structure of law, which is at its heart what I personally love the best. But the state cases are deeply interesting because they pose the power of our societal. It's where you see the law of our societal interests and the individual concerns, and balancing those two things. That's so in many cases they're very sensitive cases, and they are the law in its most how do we structure our society so that it achieves the proper ends. So, and they also involve the balance of the powers. It's where the judiciary really is fulfilling its role as in the checks and balances, if you will. So I would be remiss to not bring that forward. That's also why those cases are so interesting. A lot of them come up in an administrative setting, of course. So that's where we see that separation of powers in action. Where we're well instructed by precedent that we're not to unduly interfere with the executive power. And, so some of those cases are a little standoffish, if you will, in a judicial way. to put it in plain English. But yeah.
One of the things that's always struck me about your court is the number of people that your decisions affect, because you're dealing with state government and policies like that. I mean, like, if you're just deciding, I don't know, a personal injury case, unless you're making some pronouncement of law, it really affects two parties. Your cases on state government policies may affect millions of people.
Thank you. Thank you for bringing that forward, because I hadn't expressed that, but of course that's true. Thank you, John. Yes.
Now, with a pure volume of cases you have, I mean, the Court of Appeals hears 170, 180 appeals a year. You hear 600, 800 appeals a year.
Yeah. Yeah.
Is there a time and a place for your court to really delve into matters of law, or is the main focus, let's resolve the dispute and let these people get on with their lives?
Oh no, I that would be so unfair. What we do is we delve in, frankly, in each and every case. You know, we really, I think you see that if anyone who reads our cases can see that we delve into matters of law, and we give ourselves the opportunity to do that. The most complex cases, the cases in which we have diverging opinions, necessarily take us longer. And I know the lawyers out there, wait. They see other more straightforward, if you will, more single issues, more unanimous decisions come down, and they're waiting for theirs. But the ones that we really are grappling with take us longer, because there might be multiple writings exchanged, and that's all happening behind the scenes. So we absolutely grapple with the cases before us. All due respect, the cases tend to, when I laughed about the Court of Appeals hears fewer, the Court of Appeals, remember, hears the cases that we have really struggled with. The ones that are most difficult for us are all that they ever get. So, the ones that are a more, I struggle for the right words, but that are a review of, was the law correctly applied? Was there an error in this presentation? That's a more simple review process in its way. You might have to read a lot, but the answer will be clear, and those cases will be unanimous. Mm-hmm. The cases where you have opposing values and perhaps opposing, differing legal approaches, those are the cases that we need to work through in that more lengthy process.
It is my observation over the decades, and I just want to see if it's yours as well, that the third department, in my experience, tends to write longer opinions. I mean, they're not long usually, but they're longer than the other departments in general. It has more signed opinions. Is that by design, by culture, by tradition, or am I wrong altogether?
No, I don't. I don't do I focus on the law of our department, so I don't do a comparison, but I have heard that it is true that we issue more individually authored decisions, certainly, than I believe the other departments do, and fewer of the memo kind of, just reaching the disposition. And that is a part of our culture, a part of our tradition, and it's a lot of effort, but for anyone who brings a matter to my court, our court, you've put such a lot of effort into it that it's clearly a grave concern, and so we try to address that, and both for the people or the parties that are in the dispute, and the sake of precedent in establishing a body of law. So that's why on the other hand, brevity is a good value. So we strive for some brevity, in our writings, and not issuing unnecessary dicta, but beyond that, we want to give a full explanation of the basis for the determination, and we strive to do that, and that culture and tradition.
Now, how many judges do you have currently?
10 at the moment.
So you're short two?
We ideally would be a court of 12, John. That would be the really good number. When I joined the court, and it's been 11 years now, I was the 12th judge, but we have not been that fortunate through much of my time on the court. And 10 is workable, but when we slip below 10, you'll see us really we have to take measures to address that lack of essential staffing.
Well, the measure that's most noticeable to me is you go to 4-judge panels.
We resist doing that to the greatest extent possible. It's less rich for us, all the reasons of diversity that we spoke about before, and having 4 colleagues to weigh in with their opinions. I can speak, I think, for every member of my court and clearly say that we prefer the 5-judge panels in every way.
I'm sure.
But we do go to 4 judges. We'll go to 4 judges on occasion also if there's a recusal, that a judge must step away, and maybe they see something as they're looking through the record, and so maybe it's belated and they realize, oh, I have a connection that might look like I'd be unduly influenced here. So, any appearance of impropriety, we're very liberal with our recusal policy, because, we can always pull someone in if necessary to review. Our court rules allow for that specifically.
Now, with a 4-judge panel, you always run the risk of a 2-2 tie. What happens when the court splits?
And that is, we have a particular court rule that allows us to address that scenario. And what we also instituted was that in the most recent round of within the last year or so, when we were down to 9 judges, we at my request, we would signal at the earliest possible moment when it looked like there would be a divergence of opinion to get that 5th judge in to review, the cases as submitted. We also have all of our arguments, of course, archived, available both for the court and the public. Mm-hmm. And so they could review. The only thing that a 5th judge would be lacking is the opportunity to actually ask their own questions, but they'd have the full material before them. So we tried to institute that at the first possible indication that it was not going to be a unanimous determination. So
now, how are the panels? You just said you should have 12. You now have 10. You usually sit in panels of 5. How is it decided which judge sits on a panel, and is there a conscious effort to rotate that to ensure that the same judges aren't sitting with the same judges all the time?
There's a very conscious effort to rotate that. There is a very conscious effort. In any given term, I should sit with exactly all of my colleagues at least some point. There should be a full intermixing and intermingling of the court in all of its various potential patterns. So there's a lot of factors that go in. The scheduling is a difficult logistical issue each and every month because you have to take into account any particular judge's scheduling needs. If they have a particular appointment or requirements. We have to take into account their standard recusals. Each one of the judges has furnished a list of law firms or other connections in which it would be inappropriate for us to preside and sit. So you have to jumble all of that together and come up with various panels. But they are very deliberately ever changing, so that we all get to work with each other. Very.
I'm sorry, go ahead.
No, go ahead. I was going to say it's a very random, any litigant will get a random group of us. So
on a given afternoon, or usually Friday morning, your court will hear 4, 5, 6 cases. Then what? What's the process from there to a decision?
I have to clarify that. There's really never a time that we hear 4 or 5 or 6 cases. And we always hear on any sitting day, virtually without exception, we hear 15 cases on a day. Now,
wow.
And there was a time sometimes we'll hear 16 cases. There are exceptions to that, but we don't hear less than 15.
So after hearing the oral arguments, what goes on next? I imagine the case is conference, but what is the process from oral argument to a decision?
Thank you. That's such a fascinating period. So the thing I think I want to start with is, one, we do know before we hit the bench who is assigned to any particular case. So depending on the assigned judge and their manner of practice, they may have already had a significant period of engagement with the real particulars, that really sinking into the nitty gritty. Maybe not. We hear a lot of cases. So from my personal perspective, as long as I hit the bench, we strive to be a hot bench. If I hit the bench with a solid understanding of the factual underpinnings, that's good. And now I want the lawyers to tell me about the law. But so we are pre-assigned to the cases, but we have not discussed the cases together in any way. And the exception to that would be a very minor, a judge might say, I'm troubled about this, just so you know, I'm troubled about this, one aspect of a case, to give the assigned judge a heads up on that. Or they might share that with the panel, but we don't have any pre-deliberation, so that when the lawyers appear for oral argument, that's the first time that we have discussed the case together. Following the argument, we have a robing room discussion. So we have a public discussion with the lawyers and each other there on the bench. And then we have the private discussion about where do we think, look, I heard you ask this, what are you thinking about that? And we have that discussion in a conference immediately after. We then will retire ultimately, to our individual chambers. We'll talk with our law clerk. We process the case, and the assigned judge will present a draft of a potential statement. We gather together, we have informal conversation about that, telephone, emails, we discuss the potential draft. We gather typically when we're not in this crazy time of history, but we'll gather, and now we do the same thing with these virtual tools, but we'll speak together about our concerns. And then ultimately after the conference, we can, if it's necessary, we will engage in exchanging differing writings. So that was a lot. So thank you, John.
No, that was very helpful. But let's move on to dissents. I haven't looked at the numbers, but a great majority of your opinions, as all of the appellate divisions, are unanimous.
Yes.
There are dissents. What is your view of dissents? When do you write a dissent every time you don't agree, or is there a certain threshold or a certain level where you feel a dissent is important or necessary?
We collaborate relative to the writings, so that it's really quite possible that one of my colleagues might put a sentence, a few words, a paragraph with which I will differ. and that process of discussion that I just described would result in revisions to the writing. So that adds to that unanimity. We're not necessarily unanimous on the first writing. We might be unanimous on the third or fourth writing, and that's what that process is. So once that's said and done, if there are truly divergent opinions based in conscience, in law, in our sense of justice, and those are going to be more apt to be when there's really a difference, not in the presentation, John, because that's an individual author's product, but in the disposition, in the real outcome, the heart of the case. Then we write separately, and I encourage dissent. It's in my view, there are two sides to a case, and even though we will often come down in the same place on that, be it a reversal or an affirmance, if there's a place of real departure, I don't discourage separate writings on that. Particularly because we are a mid-level court, if it's strong enough, it gives the litigants, the parties, the opportunity to bring that point forward to the highest court. So so I'm open to that. But on the other hand, by operation of the way the law works, many of our cases, frankly, have an answer. The question posed is, was there an error in the procedure here? And in many cases, John, you'll see the answer is no. And on the other hand, if there was an error, sometimes it's I'd say we issue a fair number of modifications, where we say, well, this was an error, but the overall outcome was proper and correct in accord with the rules.
Now, you mentioned cases that go to the Court of Appeals. There are, of course, a couple of ways of getting there. One is a couple of dissents from your court. Another, the usual method, I think, is that the Court of Appeals grants leave, but the Appellate Division can also grant leave. And this Chief Judge, and pretty much all of them in my memory, have at least on some level discouraged that practice. When do you think it is appropriate for your court to grant leave rather than just let the Court of Appeals decide its own calendar?
Yeah. There is sound policy, and for the third department, there is sound policy in allowing the Court of Appeals to choose their own calendar. There are good, strong underlying reasons why they are better poised to do that than we are. And so that said, I am continuing in what is really a tradition and custom in the third department, in that we typically do not grant leave, particularly in civil cases. And the reason for that is that the parties can present their request to us. They can then go and present their request to the Court of Appeals. And those sound policy reasons are that the Court of Appeals is better poised to do a comprehensive overview. It's very common, John, for the same legal issues to be percolating up in various venues. And so what the Court of Appeals has the opportunity to see, which we do not as much, is maybe this same legal issue is presented in a case from one of our sister departments, but the issue is more squarely posed. It's maybe better preserved, which allows them to reach it. There are things, and maybe, and you see them do this all the time. They may take 2 or 3 cases together and hear and address that issue. And that's their function, and the distinction between their role as a court of law and our role as a mixed court of fact and law is really plays into that. On the criminal side, it's more, that's a different analysis to some extent because it's a one court review. So those we might be more willing to allow or grant leave. And there it would be an issue of seeing, is it a substantial legal issue? You know, is it something that we think the court should grapple with? So, but
Now,
again, people will confuse the factual and the legal review, you know, and the to the extent that it's, you know, clearly the weight of the evidence. A lot of, if you look at our criminal docket, you'll see a lot of cases fail to preserve the some of the critical issues in criminal cases. They come to us unpreserved. We'll still do an analysis of all the factual issues before us, but there's really nothing there for the Court of Appeals to work with. So
because the Court of Appeals doesn't have fact-finding jurisdiction.
exactly, yeah.
Now, in addition to your judicial responsibilities, you have considerable administrative responsibilities on several different levels. You've got administrative in Albany. You have other local, if 28 counties is local, responsibilities. And you're also a member of the administrative board, which includes the other presiding justices and the chief judge, which has administrative responsibilities statewide. What sort of issues does the administrative board tackle, and how often do you get together?
We gather physically, not quite monthly, meaning 10 times a year. So we gather literally together 10 times a year. We meet and discuss somewhat more often than that. And there are really two sorts of things. There's the formal administrative agenda, in which is devoted to, you know, rules of conduct, rules of, you know, court rules, those sort of issues. For instance, we just passed the humanitarian exception, you know, allowing lawyers to assist needy litigants, those sort of things. Those are rules. But then there's also, we communicate together less formally on an ongoing basis, sort of as needed, because the 4 appellate divisions are striving to work with the consistency, to reach consistency and uniformity to the extent that that's possible. We have different populations and different needs, and you know, but clearly the legal community has requested, you know, as our world gets smaller, the legal community wants and asks for a greater uniformity of practice. And so I think in response to that, the 4 PJs have been working in a very collaborative fashion, in at least during my tenure. We try to make it so that it's not necessarily all the same, but pretty close to. In terms of the rules of, we just issued the temporary practice orders, you know, to allow young law grads to, and if you were to look at those, you'd see they're almost entirely uniform right across the board. All 4 departments, the same application. That was a process of our the collaboration that I'm describing.
I know there was also a concerted effort to make sure the disciplinary processes are the same, and that the same conduct that results in a disbarment in Buffalo will result in a disbarment in Albany, or not.
Precisely. There was a collaboration that preceded my tenure as presiding justice, and, you know, Karen Peters, my predecessor, was heavily involved in trying to create uniform rules of practice before the appellate divisions, the uniform disciplinary rules. So I inherited some of that and have continued in that vein. And the e-filing rules. You know, we don't want you to have to do things so differently from one department to the other, because that's the underlying reality, is that a lot of lawyers will practice in multiple departments, and
Sure.
and that what's justice here should be justice there, you know, in following up on, you know, regarding the disciplinary proceedings. They're not identical, John. They operate differently. The Attorney Grievance Committee has a different manner of operation in regard to how it's approached, but the results shouldn't be grossly disparate. They should, you know, and that's the aim.
2 final fun questions. The first one, let's imagine that an attorney is about to argue before you first time. What is your advice? What should she do, and what should she by all costs avoid doing?
The key the key is preparation. The key to success in all things is preparation. So knowing the facts and the record is really the heart of it, because we might ask questions that are not what you were fully anticipating, and your ability to describe what happened in the trial scenario that you're asking us to review, in the procedural history that you're asking us to review, your ability to give an answer to that, even though it wasn't briefed, is really critical. The thing to avoid, the most important word is civility. One must be civil and professional. This is not a personal business. And the one thing that I'd say, every judge of our court, we don't scold when we see it. We'll see it sometimes, any kind of personal attack, whether it's in the brief or heaven forbid in the courtroom before us, any sort of a disparagement of opposing counsel or the opposing party. It really, we know it's a conflict. Our goal is to elevate it to a level of objective review and determination. So that takes a professionalism and civility. So to function best, that's what we need. That was a very long answer. I apologize for that, but
that was great advice, and it'll be very helpful to people. So, and finally, the trial judges, what do you wish that they better understood, or what should they know about the Appellate Division, and how important is the record on appeal?
Oh, the record on appeal is the last part. Is the record on appeal is our it's everything. The most important advice to trial judges, because they can overlook this, is that they'll have a conference with the lawyers. Some agreement will be made, and everyone will be ostensibly on the same page. They go back into the courtroom, and if that's not put on the record, it didn't happen, because right. So that's that's very challenging. So anything that a trial judge does should be at some point put on the record in a meaningful way, so that to provide for review. The advice I'd give. So that's advice one. But the other thing is that don't ever take reversals personally. This is not every single one of us spent time in trial courtrooms, in trial settings, from a broad variety of perspectives, really. We served as lawyers and then as judges, and, we know how busy it is. We know how hard it is to juggle all the parties in the room, and you've got 20 minutes or half an hour. We are not unaware of that. Our role is to review and to see that decisions were made appropriately, but it is not a personal. It's not a personal slight. It is part of the process, and please read the decisions, and because we try to be instructive and send. When I write a decision, John, I will include citations, and I do this very deliberately and intentionally. I include citations that will open the window to the primary foundations, and that will show sometimes the nuance of like a compare, well, here, this was a slightly different factual scenario, and look, a different that's so that you can literally see my cases and read the cases I'm relying on, and understand whatever that arena is in its context. So
that's great, Judge. Thank you so much for your time.
Thank you. It's been a pleasure. I as you can tell, I like to go on about these things. It's really fun to think and talk about, and I appreciate the opportunity, John.
It was fun for me too.
Thank you.